Well, thank you for that introduction and for inviting me to give this lecture. Today I want to talk to you about the body, how we understand the body within the criminal law. And I'd like to make an argument in support of what I think is quite a radical reconceptualization of the body, where it might begin and where it might end, or at least radical for criminal lawyers. And I'm going to focus on one aspect of criminal law in particular, what we call the non-fatal offences against the person. And I think even the legally uninitiated in the room might have some sense of what I mean by that. You might have heard of assault or battery, actual bodily harm or grievous bodily harm. I'll spend a little time early on in the lecture today sketching out the details of these offences. But for now, I think I'd just prefer to give some illustrations, some examples, which might highlight the role that the meaning of the body plays in this area of the law. So I'd like you to imagine two students, Eleanor and Tahani. And Tahani is an irritant to the librarian because she keeps hiding the reserve books in the library, misfiling them in obscure places, so that she has first dibs when it comes to doing the supervision reading for that particular week. And this frustrates Eleanor, unsurprisingly, but she lashes out and she hits Tahani. Now, at this point, we might say that Eleanor has committed a criminal offence. She's committed battery. I hope those of my law students in the room know that already. But what if Eleanor struck Tahani not on the arm or the face, but on her wheelchair? Would that still be a battery? Imagine Maggie. Maggie takes a baseball bat and she hits Richard on the leg and breaks his leg. She's just fed up of him pushing in the queue at lunchtime. She'd be liable for causing grievous bodily harm with intent. That's quite a serious criminal offence. But what if Richard's leg was the prosthetic limb? What if she broke his prosthetic leg? What offence would Maggie have committed then? Today, I'm going to explain why the law already regards Eleanor as having committed a battery against Tahani, but wouldn't regard Maggie as having committed grievous bodily harm against Richard. The criminal law is based on a conception of the body that excludes prosthetic limbs and mobility aids and other assisted devices. And I'd like us to stop for a moment today and question some of the assumptions underpinning that conclusion. I'm going to suggest that we should reimagine the boundary of the body beyond its traditional biological basis, where skin and hair and nail meet the air, and instead encompass mobility aids and prostheses. I think this is necessary if we're going to properly recognize the harm that particularly Richard, or someone like Richard, has suffered in this sort of example. And it's also necessary in order to properly capture the nature of the wrong committed by someone like Maggie when she takes that baseball bat, hits Richard in the prosthetic leg, and breaks it. In other words, I think we need to really question, maybe mess up a little bit, this distinction between what constitutes the property and what constitutes the body, so we can reimagine a criminal law which no longer overlooks a wide variation of embodied experiences of people with disabilities. Now, at this point, I just want to add a sort of big caveat, really. This aspect of my research was born out of the work, some of the work I was doing with the Oxford Disability Law and Policy Project before I came to Cambridge. My friend Marie, who chairs the project and painted the fabulous image on my title slide, got in touch with me, and she outlined a scenario much like the one involving Eleanor and Tahani. It had happened to someone she knew in real life, or at least something like it. And she asked me whether I thought a criminal offence had been committed. And because I'm an academic criminal lawyer and I didn't know the answer off the top of my head, I got to work. And at that point, it's one short step to wondering how the criminal law might respond if a prosthetic or a mobility aid was damaged as a result of a defendant's assault. But I don't have a disability. I've never used a wheelchair or a prosthetic limb, so I can't speak of any personal experience in that respect. And for that reason, I'm particularly grateful to Marie and to others, particularly at a conference in Oxford last year, who do have relevant personal experience and who gave me many sort of helpful comments, questions, and other forms of input, without which this work would, I think, be very much impoverished. So with that said, let's go back to the non-fatal offences against the person and develop a clearer idea of the law we're setting out to apply and critique today. Now, I mentioned assault and battery before. These are the least serious of the sort of mainstream offences against the person. Someone commits battery when they intentionally or recklessly contact, touch another person. It doesn't have to be aggressive or forceful, just any kind of touching. Non-consensual touching is sufficient. Someone commits assault when, in essence, they intentionally or recklessly cause someone else to apprehend an imminent battery. So if I raise my hand in front of your face and you think I'm about to hit you, but I don't, I commit an assault. If I hit you on the back of the head and you don't see it coming, I commit a battery. And if I raise my hand in front of you and then I hit you, I commit first an assault, and then a battery. All of these are charged under Section 39 of the Criminal Justice Act as common assault, but there is a technical distinction between the two. The more serious offences against the person are found within a rather old piece of legislation, some classic Victorian legal reform. And this Act contains a range of really highly specific offences. I don't know whether the Master's ever heard of Section 36 of the Offences Against the Person Act, obstructing or assaulting a clergyman or other minister in discharge of his duties. But there are three sort of mainstream general offences in this piece of legislation that we're going to focus on today. And I'm going to give you a sort of definition of these offences, but I've pared them back a little bit so we can just focus on the most relevant aspects for this lecture. So we have Section 47, assault occasioning actual bodily harm, or ABH. Defendant commits an assault or battery which results in some level of injury. It's not a really serious injury, but it's more than merely trivial. If really serious injury is caused, you might be liable for either Section 20 or Section 18 grievous bodily harm. If you intend to cause really serious injury, you'd be liable for the Section 18 offence, maximum sentence life imprisonment. If you intended a lesser form of harm or you were reckless as to causing at least some harm, then you'd be liable for the less serious Section 20 offence. Now, there's a lot that could be said about how these offences sit together in a hierarchy, why these two offences have the same maximum sentence, and then we get this big jump to a maximum sentence of life imprisonment for Section 18, how we distinguish between actual bodily harm and grievous bodily harm, why some of the language in the statute is so archaic, but I'll be supervising on that at the end of term, and I don't want to give the students too many spoilers. So I think this simplified sketch for now will do. It's going to give us a working understanding of the key offences. So now we're all we're on a slightly more even playing field, those of you who didn't study law here at Trinity Hall. Let's go back to thinking about how they apply in the scenarios I outlined at the beginning of the lecture. The offence of battery actually already exists, already applies to non-consensual contact with mobility aids, with wheelchairs, with prosthetic limbs. To understand why that is, which seems quite odd actually, if what I'm saying is damaging a wheelchair or a prosthetic limb wouldn't amount to ABH or GBH. To understand why battery already extends this far, we need to understand a little bit about the nature of the offence of battery, what makes it quite distinctive. It's not battery and assault, they're not offences of violence. They're often thought of in this way, but they're actually offences which are designed to protect personal autonomy, privacy, that sense of personal or body space. Going all the way back to Blackstone, assault and battery have been based on this recognition that every person's being is sacred and no one has the right to meddle with it. And this explains why the actus reus, the act component in battery, is exceptionally wide. A touching doesn't need to be hostile or aggressive or rude. It can be direct or indirect. You can commit battery by touching someone's clothing. You don't even need to touch someone through their clothing. Just the touching of clothing is sufficient. The offence of battery applies to any part of the body or anything attached to it or practically identified with it. And you can see this at work in a US case, Nash and State from the Florida Court of Appeal, where a defendant was held to have committed battery when he grabbed the complainant's, the victim's closely held purse. That was enough. Now, my point here isn't that prosthetic limbs, wheelchairs, mobility aids, assistive devices are akin to clothing. That's not the point I'm making. It's simply this. If battery already extends to clothing, then there's no reason to stop there. As a matter of applying the existing legal doctrine, non-consensual applications of contact or force to mobility aids, to wheelchairs, to prosthetics must also amount to battery. This isn't just a doctrinal argument. This must be the proper understanding of this particular offence. And to see why, we can think about cases involving self-defence. So I'd like you to imagine that you're wearing a long scarf and you're walking along King's Parade, and I just come along next to you and I take just the end of the scarf. I'm not touching you through the scarf, I just take the end of the scarf. And you're not apprehending that I'm about to hit you or anything. I'm just really annoying. And I'm not trying to stop you, keep you still, right? Restrict your movement. I'm very happy to walk along with you. I'm just really annoying. And you say, please let go of my scarf. And I don't. I laugh and carry on regardless. And you more forcefully unhand my scarf. Thank you very much, Dr. Tolley. And I ignore you because I think this is very funny. What can you do to stop me? Because if you bat my hand away, if you make contact with me, if you push me away, you'd only be acting in self-defense if I'm committing an offense by taking hold and keeping hold of your scarf. Battery needs to be this broad. Battery must protect personal space and apply to non-consensual touching of clothing, of mobility aids, of wheelchairs, because otherwise people would lack sufficient protection of their individual autonomy and personal integrity. And if you think the scarf example is a little bit facetious, well, here's I think probably a more commonly occurring issue. Imagine you're in a wheelchair and you're in a bar and someone decides to use your wheelchair as a handy rest. Quite ignorant, quite rude. You ask them to please stop and they don't. You can't do anything to repel that person if they're not committing a battery. Okay, so why have I sort of over-egged the pudding on this if it's all so obvious? Well, the CPS charging practice for battery is that they won't actually bring charges in battery cases or assault cases unless there is actually some degree of injury, probably a lower degree of injury than that which would prompt the CPS to bring charges for ABH. But if there's no injury, they just won't bring charges. And I think that's a real problem, going back to this idea of what happens if you're in a bar and you're sitting in a wheelchair, or what happens if you're a wheelchair user and a shop owner wants to push you over the threshold because they think they're being helpful, and they're not particularly interested in listening to you say, please don't do that, that actually might damage the chair, please stop. I think an increased degree of willingness to recognize this kind of activity as battery in the first place, and an increased willingness to charge it as such, would be a really helpful step forward in securing the dignity and autonomy of people with disabilities under the criminal law. So, if that's battery, where does that leave Maggie and Richard? Has Maggie committed ABH or GBH? Well, clearly, just because you touch something and commit a battery, it doesn't follow that by damaging that thing you also commit ABH or GBH. Go back to Nash and State and the grabbing of the purse. Right? When the defendant in Nash and State actually breaks the victim's purse, he's not committing grievous bodily harm or actual bodily harm. That's criminal damage to property. This distinction between the body and the property is doing a lot of work here. When Maggie breaks Richard's prosthetic leg, the law would treat this as criminal damage. Now, she commits a battery, but we've seen earlier that battery is actually quite a low-level criminal offence, can only be tried in the magistrate's court, 6 months imprisonment maximum sentence. It's not really capturing the reality of what's going on here in this violent attack. And describing the damage to Richard's leg as criminal damage to property, I think also radically underdescribes the reality of what's happening here. I'd like to suggest that we should recognize this damage as grievous bodily harm. Now, I think there are 3 sort of more minor objections to this position I'd like to stake out. I don't think any of them are particularly persuasive. So that always gets a laugh. So the first objection is, without pain or the risk to life, the victim can't suffer bodily harm or grievous bodily harm. Now, that's not true. There we go. Those are my citations. the courts have already, in 2 cases, unhelpfully both called DPP and Smith, decided that pain isn't necessary, dangerousness, risk to life isn't necessary for any injury to constitute grievous bodily harm. And in fact, the courts have held that just cutting off someone's hair can amount to actual bodily harm. That's not particularly painful when I go to the hairdressers, I don't know about you. So I don't think this is a particularly plausible exception. What about this idea that a mobility aid is fungible? It can be easily and quickly replaced with an interchangeable replica. Now, I think this is actually false. The assumption underpinning this is false. Mobility aids aren't quickly and easily replaced. It can often be quite a long and difficult process to have a replacement limb made. If wheelchairs are particularly designed for the particular wheelchair user, then it can take a long time to get a replacement. And there's, of course, a huge impact on the victim in the intervening period, loss of mobility, possible mental health ramifications, physical health ramifications that might go along with this wait period. So I think this counter-argument is based on a false premise. But in any event, to go back to the more recent DPP and Smith, if I cut your hair off, I can commit ABH. Well, your hair is just going to grow back. We already recognize the fungibility of the cells in the body, right? If I commit ABH by wounding you, a sort of low-level, not particularly serious wound, your skin cells will grow back, and there's no guarantee that you're going to get any scarring, right? So there may be no lasting physical legacy of the injury you've suffered. So I'm not persuaded by this objection either. And the third minor objection, well, how on earth can we grade severity of injury? Is this so trivial it's just a common assault? Is it a bit more serious, so it's an ABH? Is it really serious, so it's either Section 20 or Section 18 GBH, grievous bodily harm? Once we move away from traditional notions of the boundary, we lose the ability to draw those distinctions. Well, not so. I think loss of functionality is probably much more measurable than subjective questions like pain, or other forms of sort of physical damage. Okay, so what's the big concern? I've left the big problem till last. The major objection is, well, this just all starts from the wrong place, because this distinction between body and property can't be extended, can't be muddied up, can't be transgressed in the way that I'm suggesting. A prosthetic limb, wheelchair, other forms of assistive devices, they just are pieces of property. They might be very important pieces of property, but they don't constitute part of the person. Now, I think this narrow, traditional, orthodox understanding of the body we can state this description as one of objective fact, but it's a philosophical position we're staking out here, and not one that's universally accepted. So we might think about some of the work of Merleau-Ponty and others who describe this concept of embodiment. And this is an example Merleau-Ponty gives, which I think is really interesting. So when a blind person uses a stick, the stick is no longer an object perceived by that person, but rather it becomes something with which they perceive the world around them. Through this person's sensorial perception, their body extends through the cane. What was previously a mere object becomes the interface between the self and the rest of the world. And Miko Iwakuma describes something a little bit similar. When the lover of a person in a wheelchair touches the chair, she shivers as if the flesh of the person was caressed, and in a sense the person was touched. The lover touched the wheelchair as an extension of the person. And these phenomenological understandings of the body, extending through objects, integrating objects into the sense of self, can be found in psychological research, particularly in the work of a psychologist, Craig Murray, who's looked at how the community of medics working with prosthesis users try and ensure good clinical outcomes. So Craig Murray says that the rehabilitation community working with prosthesis users often talk about the need to transform the prosthetic limb from an inert supplement or an extracorporeal structure to a corporeal structure. I hate pronouncing those words, sorry, you have to excuse me. So the idea is that the users of the mobility aids start to integrate them into their own body image, to embody them as part of them rather than everything else that sits on the other side of this interface between the self and everything else. Now, I think it's really important here that I don't want to suggest that all people who use mobility aids are one homogenous group. That's clearly not the case. I think it's also really important to recognize that there need not be one right way of experiencing a prosthetic limb, a mobility aid, any other form of assistive device. And actually, this distinction between body and property might not necessarily be binary at all. It might be far more complicated than traditional concepts of body versus property might allow us to recognize. In terms of my work in the criminal law, the law has to, I think, adopt a position which includes a degree of predictability. People need to be able to plan their lives accordingly. They need to have a sense of how this coercive legal institution will respond to their conduct. And so criminal lawyers don't like mess. We don't like blurry lines. We like certainty. We like consistency. We like predictability. And so it might be difficult to just say, well, look, this distinction isn't binary, it's messy, and anything goes. But I think it is certainly clear that however difficult, however blurry this boundary is, we can't say something so simple as prosthetic limbs and wheelchairs are clearly property and not part of a person without excluding and ignoring the lived experience of significant numbers of people who actually live in that day-to-day reality. It's quite a narrow view of answering this question, I think, to just pretend this concept of embodiment and this psychological research doesn't exist. So if we do extend our concept of actual bodily harm or grievous bodily harm beyond traditional biological boundaries and capture damage to prosthetics or mobility aids, wheelchairs, etc., within our understanding of ABH and GBH, I think we're left with three key challenges. The glasses question, this is the one I always get, so I'll deal with it first. The in-use, out-of-use distinction, what happens if the defendant damages the mobility aid when it's not in use? Is that still harm to the body? And the individual difference question, what happens if this particular victim doesn't embody their mobility aid, but rather regards the defendant's conduct as damage to their property? How should we deal with that? Okay, so let me deal with the on what counts question, the glasses question. Does this extend to glasses? Does it extend to hearing aids? Where do we stop? Mobile phones, adapted cars, guide dogs. I actually think this is less troubling than it may initially seem. I think it's important to bear in mind that I'm not arguing that we should extend our understanding of the body based on a functionality analysis. The idea isn't that there's some normal conception of the body and people are impaired in a certain way, and so they need to have some kind of way of replacing that functionality, and anything that replaces this functionality, this normal quote-unquote functionality, amounts to something that's the body and something that's not. It's a very different kind of analysis that underpins this argument. And it might be the case that people can embody their glasses, truly integrate them into part of their sense of self. They see it as this thing which is them, with which they interact with the rest of the world, rather than some part of the rest of the world that they sort of use frequently on a day-to-day basis. I think that's probably plausible. And I suppose I don't have a great deal of concern, actually, in suggesting that if you're wearing your glasses and someone breaks them, particularly if now you're really struggling to engage on a day-to-day basis because, the glasses are really important and you can't see, which I think probably makes it more likely you're going to be embodying your glasses in that way, that we can describe that as an assault on your person rather than on your property. I'm okay with that. And I might be okay with that because I find it difficult to imagine breaking someone's glasses and not causing some low level of injury. And I think most breakages of glasses probably won't even meet the ABH threshold, actually, would probably, unless it's really difficult to get those glasses replaced. And so you're going for a long time with a significant loss of functionality in the intervening period. I think you're probably staying in the common assault framework rather than the ABH framework in any event. But I don't necessarily have a problem with this so far. Mobile phones, I think, sit on the other side of the distinction. So I think what I need to do here is to recognize that, look, there's an agenda behind this research project. I'm primarily concerned with how the criminal law recognizes the bodies of people with disabilities. And I think this narrow biological understanding of the body speaks to a broader social problem of exclusion, of lack of involvement, of lack of voice in the way that we imagine who we are as people and how we interact with one another. And so if on the what counts question, we might say something like, well, if you have something which amounts to a disability under the Equality Act and you have some kind of mobility aid or assistive device which you use in connection with that impairment, then that's capable of amounting to part of the person under the law rather than property. That might be a useful way to draw a predictable line in a very muddy, unpredictable area. Now, that's not going to be a perfect knife cut through what, as a matter of theory, ought to sit on the body part of the line and what ought to sit on the property part of the line. At some point, we have to make approximations, make determinations. We have to have a law which is either over or under inclusive. We have to accept that. But I don't know, I find the glasses question a lot less concerning than a lot of my interlocutors do. That might be informed, I guess, by my approach to the in-use, out-of-use distinction. I forgot one point, sorry. There's one thing, one assistive device or mobility aid that I think should not count, even if it's used in order or in association with an impairment which would count as a disability under the Equality Act, and that's guide dogs. Because I think a sentient being can't ever, this sentient being, can't ever transgress the interface between self and other to become part of the victim. This is always another sentient being. In a way that glasses, your hearing aid, your wheelchair won't be. And I think a good way of testing that is, let's say you have your glasses, you have your wheelchair, you have your prosthetic limb. There's nothing to stop you breaking it. Right? You can break your prosthetic limb just like you could break any other part of your property or any other part of your body. That's entirely up to you. But you can't hurt your guide dog. Right? That's not permissible. As a matter of law, sure, but also as a moral claim. You can't. And so I think that's a healthy cross-check on my position on guide dogs. I anticipate that coming up in questions if I don't touch on it. So. There we go. The in-use, out-of-use distinction. What happens if the defendant damages the mobility aid, the wheelchair, the prosthetic leg, when it's out of use? Well, I actually don't know how people who use mobility aids envisage their mobility aids when they're not in use. I've talked to some people about this, but this is all sort of very anecdotal. There's not a lot of research that I've been able to find on this point. In the same way that there's significant amounts of research about how people embody their mobility aids when they're using them. So there's a gap in understanding here which makes giving you a neat theoretical answer quite difficult. But I'm interested in this within the context of the criminal law. And we have to balance all sorts of values against one another when we're trying to figure out how to best construct criminal law rules. And in criminal law, we care about certainty and predictability. We care about giving people an opportunity to conform to the law. We care about being able to figure out what the law is, how the law is going to apply in advance, rather than just deciding ad hoc on a case-by-case basis afterwards. And so I think how we draw this distinction needs to be predictable for defendants too. Right? Not just easy to apply for judges or for juries, but predictable to defendants before they engage in wrongful conduct. So I think when a mobility aid is in use, the defendant's on notice that if you take that baseball bat and you hit this person in their prosthetic leg and you break it, or you hit their wheelchair and you break their wheelchair, that you're possibly committing an offence against that person. I think the defendant is probably going to be integrating that mobility aid into their understanding of what this person's body image looks like. I think that's a lot less obviously the case when the mobility aids aren't in use. And so at least on the face of the legislation we have currently, that Offences Against the Person Act, which isn't, I think, subject or isn't particularly open to fine-grained distinctions being drawn within the scope of the existing criminal offences, I think we should maintain this in-use, out-of-use distinction if the law's to be further extended to encompass damage to prosthetics or wheelchairs. And that might help me answer the glasses question, Because if you break someone else's glasses when they're not wearing them, you won't be committing an offence against the person, principally because they're out of use rather than in use. You might be a bit happier to accept damage to glasses as capable of amounting to ABH or GBH if they're on your face while it happens. I don't know. A lot of you have glasses. You can tell me in the Q&A. And the third key question is this one, victim experience and embodiment. What do I mean by that? Well, it might be the case that two defendants do exactly the same thing. Like Maggie, they take a baseball bat and they break someone's prosthetic leg. And Richard, let's say Richard embodies his prosthetic leg. He regards what's happened to him as damage to his person. This leg isn't just a piece of property, it's his leg. But Maggie goes and hits Meredith with a baseball bat next. And Meredith has a prosthetic limb. And Meredith doesn't embody her prosthetic limb. She doesn't see it like that. She sees it as, I don't know, maybe something that's actually quite inconvenient. And she's much happier when she's not wearing it. That's how she sees her body image, her sense of self. Right? She doesn't need the prosthetic to feel intact. She regards this as damage to her property. Quite a serious wrong, right, because of how significant this piece of property is to her, but she regards it as damage to her property. How's the criminal law supposed to respond given that victim experience can be highly varied? As I said before, I think we have to accept that the world is messy. But criminal lawyers like to try and impose order on chaos and disorder. Criminal lawyers at least need to ensure that rules are predictable and applicable. And so it's difficult. It would be difficult, I think, to vest this distinction between is this criminal damage or is this ABH or GBH within the victim herself. I think that would be quite tricky because there'd be no way of assessing ex ante whether you're committing ABH or GBH or criminal damage. And there might be all sorts of difficulties in assessing whether or not the victim genuinely did experience this as damage to property or as damage to their person, not least if the victim isn't around to ask after the event. How on earth would we respond in that kind of scenario? So I think we probably do have to make a decision. We have to go over-inclusive or under-inclusive. And we have to accept that there's a risk that the criminal law will be seen then as endorsing this idea that there's one right way to have a prosthetic, and I think we should be very keen to emphasize that that's not the case. We're not saying that two legs is normal and a prosthetic, in order to have a sort of integrated sense of personhood, you have to have a prosthetic limb and you have to embody that prosthetic limb because that's part of you. That's not what the criminal law is saying, right? What we're saying is, yes, it's messy, but predictability is a value that we need to achieve in the criminal law, and so we have to go one way or the other. So let's be over-inclusive. Let's recognize that even if certain victims understand what's happened to them as property damage, we're going to recognize it as actual bodily harm in the criminal law. And there might be advantages to this. And I think one of the principal advantages is there might actually be contextual factors which impact the extent to which someone comes to embody their prosthesis or see it as part of their person, or at least see it as in some kind of sui generis state that this binary body property distinction can't quite capture. There might be vectors of privilege which affect how likely an individual is to come to this kind of position, how long they've been using that mobility aid, how much influence, how much voice they had in the process of its development, how good it is. Have they received a lot of support in figuring out how to use it, how to integrate it into their bodily functionality. So we might see stratifications of those who do and who don't embody their mobility aids along other forms of privilege, socioeconomic or otherwise. And we might worry that by vesting this distinction between body and property, or at least between criminal damage and ABH or GBH, within the victim herself, we risk compounding that lack of privilege compounding those barriers to embodiment and integration all over again. And I think there is value in recognizing through the criminal law damage to prosthetics, to mobility aids, to assistive devices as damage to the person, even if this particular victim doesn't quite see it that way, because we're sending a message, and a really powerful one. And it's a message that recognizes the respect and the dignity, respect for and the dignity of people who use mobility aids in a more profound way than the criminal law currently does, when it says Richard, with this broken prosthetic leg, has simply been a victim of battery and criminal damage. So this law, the Offences Against the Person Act, battery, assault, the common law offences, this part of the law is notorious amongst scholars, amongst students. We academics love it when we set essay questions because there's just so much to say. The language is archaic, it's preoccupied with all of these 19th century ideas, which have very little relevance to today's society. It's got an incoherent structure, it lacks any conceptual clarity, it lacks textual clarity, it's quite unfair often in the way that it's applied. And so there's huge amounts of critical literature on this subject. The Law Commission looks at it, periodically, screams into the dark abyss of a legislature who are too busy with Brexit to think about criminal law reform. And so the Law Commission actually published a scoping report and paper a few years ago, and I don't think anything's come of it. It's a great paper, but it completely overlooks all of these concerns. So I would like to hope that if we ever get to whatever post-Brexit looks like, and start thinking about criminal law reform again, we might think a little bit seriously about how to close up this lacuna, about how to increase the protection the criminal law offers to people who use mobility aids and prostheses, assistive devices, to how to better recognize their embodied concept of themselves within this understanding of the body sort of envisioned by the criminal law. I'm not hugely hopeful, but I'll keep trying. Thank you very much.
Okay, so thank you very much, Rachel. That was fantastic, really clear, and I'm sure it's raised a lot of questions, so do put up your hands. And please wait until the microphone comes round.
John Platt, retired circuit judge. Obviously, there's a huge overlap between what you propose and the law of criminal damage. Mm-hmm. And you were expressing some doubts as to whether it would be wise to have the victim making the choice. Well, perhaps you're not a family lawyer, but if you look at the Domestic Violence Crime and Victims Act, we have already had, and Parliament has accepted this situation, in that if there's a breach of a non-molestation injunction, the victim decides whether to go for contempt of court in the county court or to go for a criminal offence which carries a maximum sentence of 5 years.
Oh, interesting.
Now, this was my special field, and I'm here to say that it's a very bad law because we lost the right power of arrest, and domestic violence injunctions dropped off a cliff. They nearly halved when the law came into force because everybody wanted powers of arrest. But anyway, Parliament said otherwise. But conceptually, it works.
And it works well.
It works well. And in fact, most victims prefer to come to the county court. Of course, there's a practical reason, because the judge who's hearing the case has got the whole file of papers in front of him, whereas in the Crown Court, it's only the actual incident which is evidenced. And so lots of victims have gone to the Crown Court and failed, not guilty verdicts. I mean, you're asking 12 ordinary people to talk about a matrimonial dispute.
Yes.
You know, frankly, not guilty verdicts are expected. And so I think most victims now come. And I think you'll find with disabled people that their own perceptions, as you said, are different.
That's
and
true,
so why not recognise their difference? If they regard it as criminal damage, then let them accept that CPS accept their advice and say, we'll charge criminal damage.
So that is the most difficult issue, and it's the only, that what really troubles me about the position I've ended up coming to in this paper is precisely that we're taking that voice, that decision-making away from disabled people, from people who use mobility aids, in trying to say how they understand what's happened to them. And I'll have to follow up on, so what piece of legislation?
It's the Domestic Violence Crime and Victims Act, 2004.
2004. Yeah, so I'll have to have a look at that and how it works, because if there's already examples of vesting this kind of decision making in the victim operating well within I guess the criminal law, the intersection between the criminal law and family law.
Contempt of court is a crime for Human Rights Act purposes, certainly.
Yeah, then it might be that I can resolve myself of the concerns that have so far proved decisive, and reach a much happier outcome, which is consistent with all of the other concerns I have on the other side. So
now, in your example, what happens if the gentleman with the prosthetic leg is hit with a baseball bat, but his prosthetic leg is made of titanium and suffers no damage at all?
Yeah, so then it would be an attempt.
An attempt.
An attempt. But if you take a baseball bat and you hit someone's prosthetic leg under the current law, you can't be convicted of even attempted ABH or GBH if you knew it was a prosthetic leg and you were only intending to break, to damage the prosthetic leg. So you have to extend the understanding of what constitutes bodily harm in order to even get to an attempt in the titanium leg case.
But you could still charge this as attempted criminal damage, couldn't you? I mean, the intention...
Under the current law.
Under the current law,
yes. But I think the problem with charging attempted criminal damage in that sort of scenario is exactly the same problem you have with charging the full criminal damage, the completed criminal damage offence if the leg breaks. And it's just that it radically under-describes certainly the wrong committed by the defendant as well as the harm sustained, at least by some victims. Another point we might make on the vesting, the distinction between the criminal damage and bodily harm in the victim is, it might be that the victim understands what's happened to them as damage to their property, but it might be that the defendant understood what they were doing as causing harm to the person. And so you might, there's another reason in favour of over-inclusivity on the victim experience point, and that's, we're not just trying to capture the nature of the harm suffered, we're also trying to accurately label the nature of the wrong as it's committed by the defendant. And if what we say is, well, the nature of the defendant's wrong is an assault on someone's person, not on their property, however it's understood by the victim, then there might be another reason in favour of over-inclusivity there. But I take the point that limiting the relevance of the voice of people with disabilities in this debate is a real problem.
Thank you.
Another one at the end.
Eamon O'Tierney. Was interested that you said that you started off by saying the 1861 Offences Against the Person Act was not very well known, as we've just abolished, decriminalised abortion in the north of Ireland by repealing sections 58 and 59 of it for the north of Ireland. However, I'm much more interested in what you just were discussing with this gentleman was about the victim's experience and whether that would be relevant. But what worries me is, as a defendant, how would you know what the victim's attitude was to the prosthetic?
Yeah.
So if you were hitting somebody's wheelchair with a baseball bat, you might think that you were just harming their property rather than their person.
Yeah. So I think the in-use, out-of-use distinction helps, because I think if the mobility aid or assistive device is in use, then the defendant can be said to have been sort of more on notice, if you like, that this possibility is live, because the defendant is engaging in an assault, at least on something which is so closely attached to this person's personal space, right? So closely bound up with their traditional body, the biological body as it's traditionally understood, that we might say the defendant is on thin ice here. And they're on thin ice because they're committing a criminal offence one way or another. And if you skate on thin ice and the law doesn't precisely mark out the boundary where it gets too thin, and then you fall through, well, then you don't have very much complaint to make. That thin ice argument crops up in sort of various aspects of the criminal law, and is sometimes more persuasive than others. But I think there's something to it here. I think if we maintain this in-use, out-of-use distinction, and we're saying, well, look, if you come along and you take a baseball bat to someone's prosthetic limb or to someone's wheelchair and you break it, you might end up being convicted for grievous bodily harm or actual bodily harm. I think the objection that, well, I thought I was committing criminal damage is, in amongst all of the other values we're trying to balance in this kind of area, possibly less persuasive than the need to reflect the nature of the harm as it's suffered by the victim.
I know quite a lot of people through the disability community, and their attachment isn't just when they're not using it. So if I have a friend who is able to walk a few paces against a wheelchair, and goes into
absolutely.
Somebody attacks herself, she still feels herself.
And that's where the balance tips the other way, right? When we're trying to balance the interests of the defendant and the interests of the victim, interests of certainty and predictability within a sort of legal framework, there are going to be points where that balance shifts. And I think my point in the in-use, out-of-use distinction isn't that, look, the embodiment arguments as to why we should understand the body in this slightly different way just don't apply here when the mobility aids aren't in use. It's more that whatever the answer is on the embodiment issue, the defendant is no longer fairly on notice that he's possibly committing an offence against the person rather than a property offence. And so that balance just tips in the other direction.
Okay, so yes, down here.
Rachel, thank you so much for a really wonderful talk. The glasses example.
Yes.
So as far as I can see, conceptually, you are close to being committed to saying that the glasses would be covered.
Yeah.
And then sort of the questions I have about that are, how would you define actual bodily harm and grievous bodily harm? Because actual bodily harm is anything that's more than trifling.
Yeah.
So if I, slightly damage my next door neighbour's glasses, then on the face of it, then it would seem to be more than trifling. By a tiny amount of criminal damage to the glasses would be more than trifling. But are we really going to say, therefore, they should be charged as actual bodily harm? Yeah. And then grievous bodily harm is very serious for the jury to decide, I think. But then are they really meant to determine whether it's very serious in relation to the glasses or in relation to the body? Now, if it's the glasses, then again you seem to get to the problem that something which actually currently wouldn't be treated as anything like as serious as grievous bodily harm is going to be treated massively more seriously. Whereas if you go to the body, then you get to the subjectivism problem, which is that, to my next door neighbour possibly, sorry, I didn't mean to make you the, you weren't,
friend here. Who will help, with the assault.
Well, I hope they will not be, anyway, if it's the body, then you get to the subjectivism problem, which is that to one person, glasses might just be an object, which they go down to Boots, and or maybe it's more serious. They go to the Morpheus Eye Hospital and they sort out some glasses. To the other person, it maybe is deeply embodied. But then you get to the issue of how on earth would you ever know, and how would you really find the evidential value later on to determine which one was actually true before the event or not. So I don't know what you want. Yeah.
So I think those are good questions, and they can be. I think. Well, I hope you'll agree with me that they can be answered. So the first point to make is that if you actually look at the CPS charging standards on when the CPS will bring charges for common assault or battery, or ABH or GBH, despite the fact that the law sets quite a low threshold for what will constitute actual bodily harm, anything that's more than merely transient or trifling, the CPS will generally only bring charges if there's some pretty serious injury that's been caused. Not a really serious injury, that's left for grievous bodily harm, but the injury has to be pretty serious. So if you damage someone's glasses and they can go to Boots the next day and get a replacement pair, or possibly even get a replacement pair in a few days, I think it's unlikely that that would reach the threshold of ABH just on the basis of the way ABH is already understood in terms of sort of ordinary kind of cases of damage to the biological bodies. I think we can assess the distinction between ABH and assault and GBH and ABH on a loss of functionality analysis. And I think that's what allows us to grade the severity of the harm, right? So it's not, have you destroyed a bit of the glasses or all of the glasses, it's how does destroying the glasses affect this person, the functionality. Now, that's not to say that the reason why the glasses constitute the body is based on a functionality analysis, right? That's still the embodiment analysis, but when it comes to grading the severity of the injury, I think we can look at loss of functionality, because that's exactly why we'd say a mildly broken ankle is more serious than a badly broken ankle, because you're going to be off your, you can't play football for 6 weeks as opposed to 1 week or something like this, right? I think we're already in the practice of looking at functionality on the grading side. In terms of the predictability point, right? So if I take that view and I say, no, it's about how it affects the body and the use of the body and the use of the mobility aid, does that make it all subjective and unpredictable? Well, to that extent, it's perfectly orthodox in criminal law that you have that degree of unpredictability anyway, right? So there are, I think, two closely linked doctrines which I can draw upon to make this point. One is the thin skull principle, which a lot of the lawyers in the room will know, right? So if I hit someone actually quite lightly across the head, but they have a particularly thin skull because of some kind of congenital condition, and they suffer very, very serious brain damage, I'm liable for the brain damage, right? Like, I've caused the brain damage. I don't get to say, well, no, I haven't caused the brain damage, their thin skull caused the brain damage. So we already build this kind of subjectivity and unpredictability into the causation analysis. And in terms of grievous bodily harm in particular, the courts have held in a case called Bollum that, look, actually what constitutes the kinds of actions which might result in grievous bodily harm are going to vary person to person. So if you, engage in a particular form of assault in relation to a baby, you're far more likely to cause grievous bodily harm than if you perform the exact same type of conduct on a sort of robust human adult, right? So that kind of subjectivity and unpredictability is completely orthodox within the existing law on the offences against the person.
Michael Gaunt, vascular surgeon. And thank you very much for a fascinating talk and very well presented. Even as a simple medic, I understood what you were going on about it, so you were very successful.
I wouldn't describe medics as simple. I'd rather do my job than your job.
This one is. As a vascular surgeon, I often have to perform amputations, unfortunately, and John Colley was a patient of mine many years ago. And some of those, I'm going to give you an example now, just to test your theory. Some of those patients are drug addicts. Unfortunately, drug addicts often inject infected, horrible things into the femoral artery in their groin, and it gets infected, and we end up having to amputate the limb in order to save their life. But when they wake up, they're still a drug addict. And drug addicts often want to get outside the hospital as soon as possible. And we give them a wheelchair from the hospital to use, and they're frequently outside because they're meeting their drug dealer and even having their drugs injected through a Venflon or something. And sometimes they don't always make it back to the ward conscious. They're found asleep outside or in the lift and what have you. And approach in the past to prevent this self-harming behaviour and undermining all the care that we're giving them, we take the wheelchair away. So in that example, and according to the changes you're proposing, would we be committing an offence against that?
And the wheelchair is the... Yeah, very good. So is the wheelchair yours? Sorry, just to understand, is the wheelchair the patient's wheelchair or is it the hospital's wheelchair?
In the acute situation, it would be the hospital's wheelchair that we have lent to them to use in the short term.
So I think I think it would be very difficult to defend this sort of argument if what I was saying is someone else's property could become integrated with someone else's sense of self. I think you would have to say, if we're looking at, we have this kind of distinction between the body and everything else, this property-body distinction, and we're saying something which once was property can transgress that boundary and accede to the self, then I think we should probably set up as a precondition that the person owns this property to begin with, right? And I suppose I'm smoothing over some of the theoretical difficulties of exactly what this distinction looks like. I think it's probably not binary, but the law likes to deal in binaries, and I think that's probably where I'd kind of stay for now. If it's their wheelchair and you take it off them because it's in their best interests, then I think you might need a best interests necessity defence, which is difficult in the current law. But I think probably what happens is people's rights are infringed all the time, particularly in a medical context, when consent hasn't been given or can't be given because there's a lack of capacity. And so you either go down a kind of lack of capacity road, or in the presence of capacity, there's a best interest necessity defence, which I'm not suggesting you'd have one as a matter of doctrine, but that might be one way of thinking about it. But and it might be that we need to think very seriously about how to deal with precisely that kind of scenario, were we to move in this direction, to make sure that people weren't put in a legally precarious position when they ought not to be. But I think that's probably, I've not thought about that before. It's really helpful, thank you. But I suspect that's where I'd be going, the direction of travel for me.
Thank you.
A couple more questions. One over here and then one over there.
Yes, it's Philip Dan. Back to the guide dogs.
Yes.
I'm a little bit confused. I thought the guide owners will go out with the dog, and it's a link to the dog and the owner. Now, the defendant kicks the dog. What's the problem about the splint is all right, but not the dog? I'm confused.
So I think in that scenario where someone kicks the guide dog, I think we can definitely say there's a battery. I'm very happy to say there's a battery there, because the rationale of battery isn't about protecting a person from violent attack, but protecting their personal space, their personal autonomy. We go back to the scarf example. So I'm very happy to say that kicking the guide dog is a battery. The difficulty is if the guide dog is injured and you say, okay, well, now that injury constitutes actual bodily harm or grievous bodily harm against the person, what we're saying is the person is embodying not just an inert, what was previously an inert object, right, but another sentient being. And I think there's something important about recognizing the dog's rights, right? And we don't have to accept that the dog is a person, right? We don't have to accept that animals are persons in order to accept that the dog is a sentient being with rights. But the minute you allow a guide dog to transgress that boundary line between everyone else and everything else and myself, then you're denying the rights of the dog. And that's the difference.
Final question for them?
Hi,
Hi,
so
Jess.
I'm Jess, I'm the Disabled Students Officer at the university, and so I just wanted to thank Rachel as well for actually doing some research into this and thinking about disabled people in a way we are very often not. As you said, not included in any of the review into the legislation by the Law Commission, but thankfully we have you. One thing I wanted to ask about, obviously I represent loads of people who use mobility aids, who use wheelchairs, various things. I wanted to ask you about where you draw the distinction between the in-use and out-of-use in terms of, for example, like some examples, if a person was to take a blind person's stick off of them and then to snap it, is that in-use or out-of-use?
Ah, good question. Yeah.
If a person was to lift another person out of their wheelchair and then destroy it, is that in-use or out-of-use?
So I think that's a really good question, and not actually one that had been put to me in that way before. I think if my reason for drawing the in-use, out-of-use distinction is the fair warning point, right? Is the defendant fairly on notice that they're possibly committing an offence against the person rather than a property damage? So a taking and breaking, which is sort of what you're describing, right? Then I think that would count as in-use. it's not so much whether it's in use or out of use, it's a fair warning point. So we could describe that as in use, we could describe it as a sort of slightly different category, but I think the key point is the defendant there has adequate notice that he's committing an offence against the person, or at least might be committing an offence against the person. And so that would fall, I think, within my ABH and GBH framework rather than my criminal damage. But that's, I think, because we're seeing the defendant's conduct as a course of conduct rather than taking particular snapshots of like, individual act types in this sequence. And I think that's right. You would have to look at that as a sort of overall course of conduct. Yeah.
Okay, thank you.
Right. Well, I think we have done. Before we give a final round of applause to Rachel, everyone is very warmly welcome to join us